Thank you, Karen. Good afternoon, everybody. I'm Michelle Barkley, and I'm with the Committee on Justice for Children. I'm the project director and an attorney. And this project, I'm just going to introduce it really quickly, and then I want to turn it over to our 11 Supreme Court Cold Case Fellows. I don't know if that's their whole title. I think we just called them Supreme Court Fellows. And they can walk you through what we learned for this past year, what we've been working on. The Cold Case Project basically came as an idea that Defects had, some folks at Defects had, but they didn't like the name. I liked the name because it just, the TV show, everybody knew exactly what it was. And so I decided to take that name that they decided not to use, and I was going to use it for the stuff we were going to work on. The reason why we launched this project is last year we got some extra Court Improvement Program funds. That's a federal funding stream that comes to Georgia and the other 50 states. We got some extra funds for a bunch of bureaucratic reasons, and we decided to take those funds and do something unique, special project, not just support the regular trainings that we do, not just support, there's a whole lot of things we have just in place that we support, but we want to do something different, something to help us move forward as a state to do better. One of the things that the federal government has started within the last 10 years is a federal audit called the Child and Family Services Review. I've been part of that review twice. We're going to have a third one coming up in 2012, I believe. And while the review always, as all audits do, are cumbersome and they have some flaws, we learn a lot from those reviews. We learn a lot about what's going on in our state, and we do a lot of calculations of various measures, trying to figure out how we're doing as a system. And before we started doing the Child and Family Service Review, we really had no quality assurance in place at all. So it's a little bit of a learning curve, but we still have learned a lot from that. And from the last review in 2007, we learned that we did not do well as a state on permanency composite number 3. That's a very bureaucratic way of saying we have way too many children in our state outside of the target goals that we're supposed to try to meet who are aging out of foster care, and a number of those kids are legal orphans, which means that we've moved forward as a state, terminated parental rights, and they still aged out without finding permanency. And so we decided to take some of our federal funds, federal grant funds, and focus on that problem. What can we do to try to take a look at that problem? And why are we focusing on this? Permanency composite number 3 really is focused on that outcome, that child outcome, because studies have shown that that is not a good outcome for kids. Kids who age out without finding permanency are more likely to use future government resources. They're less likely to graduate from high school and go on to secondary educational opportunities. They're perhaps, not quite certain, but perhaps more likely to end up in prison, which we know we spend a lot of money on that. And so roundabout, this is the worst possible outcome our child welfare system can get for a child, so it's a good place to focus some of this energy. We decided to hire 11 attorneys. We started out with thinking we were just going to hire 6, but we had this test. We had about 45 people apply for it. These folks all made A's on that test, and then we interviewed them all, and we kept talking in my office about how we're going to narrow it down to 6, and we just couldn't do it. So we decided to cut some of the positions in half, so we had like some part-timers working with us, and we ended up actually making them, instead of having 6 people who would work 3 days a week, we ended up having 11 people who work basically 1 to 2 days a week. And I'm glad we did that. The other thing about hiring 11 of these folks is that we got a good proportion of SAGs, child attorneys, and parent attorneys, and that for the last year has been a huge benefit, I think, to the project, because everybody brings really unique perspectives to the table when we discuss cases, and it's been really helpful to hear all sides in those kind of discussions. We use a predictive model to help find the cases. So basically, we set up a number of factors to try to figure out what was a cold case, and we're still defining that today. We can still move the parameters around and get more or less into that. But we ran about 9,000 cases through a computer system that brought us through a predictive model, and about 500 children popped out that met this criteria that we were trying to define. And of those 500, we basically decided to go with half, and we also are so lucky to have Tammy Meredith with us, who is our evaluator, and she's going to be writing up a paper on this work, and she's going to discuss some of the details of these things. But from that, she randomized the 500. We ended up reviewing about half of those cases, and she'll tell you the details of that. Ended up being about 46 counties. 46 counties and over 200 cases that were reviewed, and the counties are really spread all over the state. We tried to get a really broad variety of what this case looked like. And I want to just give a huge plug to DFACS as well as the Office of Child Advocate. We could not have done this project without them. This past 2 years, they have been completely transparent with their data, with sharing everything with us. It's been so cooperative. It's really been a very, very much a collaborative project between the executive branch, the 2 branches, which is the Office of Child Advocate and DFACS, State Office of Child state defects office, and then the office, or I'm sorry, our office in the judicial branch, which is the Committee on Justice for Children. We could not have done this without them. And I have to say, it's a completely different climate from where we were about 10 or 12 years ago, and I'm thrilled. I love it. I never want to go back. So I'm going to stop here and turn it over to our cold case lead fellow, which is Ashley Wilcott. And I'm going to ask these guys, because it took so long to, I was reading their bios, and we're going to introduce them, but it would take about 30 minutes to go through it all. I'm going to ask them to just tell a little bit about themselves when they come up and talk, if you guys don't mind.
Excellent, thank you.
I'm sorry, Tammy's going first?
Yep. Okay. We're switching things around.
Hello, everyone. My name is Tammy Meredith, and I'm a criminologist and a researcher. My role on this project was to help develop the program protocol and then conduct an evaluation of what we did through the study, and I'm currently working on a report on that that'll come out in June. So I'm going to start by talking to you about the two goals. This project started out with two primary goals. First, to develop a method to improve the permanency outcomes for long-term foster care kids. What that means is we're really looking at kids who have been in foster care for more than 2 years, as Michelle said, and kids that are aging out of foster care without having a permanent placement. Our second goal has been to affect permanency in the 200 and some odd cases that we reviewed specifically. So what we did is we spent a lot of time making sure that all the proper legal requirements were done and fulfilled on the cases that we reviewed, and made recommendations for those specific cases if we felt they were worthy. Let me run through the program protocol for you. We started out, as Michelle was talking about, looking at kids that have been in the foster care system some time ago. So we went back to 2007 and started by analyzing almost 5,000 kids that were in foster care in the state of Georgia. Now, Michelle mentioned briefly that Andy Barkley worked on developing a statistical model that would predict among foster care kids in Georgia what cases would be cold, which ones would languish on foster care for a long period of time. Now, building that statistical model then was used to identify cases that we should review. So we develop a statistical model, and it's much like the auto insurance industry does when they develop statistical models to predict the chances that you're going to get in a car accident so they can figure out how much to charge you. Right? So we're doing something similar. We're looking at risk factors for kids that are going to become cold. We identified a list of 500 kids, and we randomly selected half of that list to go out in the field and review. Back in April of 2009, we hired this panel of Supreme Court fellows that you're going to hear from today. And once they were hired, we worked with them to develop and test and modify what we called a file review protocol. It ended up being a series of it's a 20-page packet that was completed, forms that were completed on DFACS files out in the field. So the fellows would go to the field and review the DFACS files and fill out these 20 pages of paperwork. So what they were doing is they're reading court orders, they're reading through case notes, they're reading child psychological assessments, collecting data on those kids. They were interviewing case managers while they were on site. And once they completed this 20-page packet, that came back to me, and that's part of our evaluation data. We completed reviews in 46 counties, 214 total cases, and those counties are important because we covered cases in every one of the DFACS 17 regions. So our goal was to make sure that we did a good job of covering the state and focusing on both rural and urban counties. During the reviews, then the fellows are going to talk to you about the 10 points of legal process and the things that they looked for specifically, and I'll come back to that in a minute. Next in the protocol then, after cases were reviewed and that 20-page packet is completed on every case, this group as a team sat and deliberated and discussed each individual case. And we came up with, were there specific case recommendations for that child? And in addition, what did we learn about that child that will help us tailor our recommendations for all children? Once those deliberations were done, then we conducted what we called follow-up phone calls with a local DFACS team. And so we had on the telephone call whoever the fellows were that reviewed, the local DFACS director, the case managers, sometimes the SAGs. We had an entire team that participated in a follow-up phone call. And what we did then is we gave them the results. What did we see in the reviews in your county? And do we have specific recommendations for certain cases that we reviewed in your county? And then you can see the next part of our protocol is that we posted our written highlights of that review and any recommendations we had on each child. So we have a summary with recommendations posted for each child on what we call Google Docs. It's a place on the internet where we can post for free information, and DFACS folks then could get, in at both the state and the local level, could have access to that site so everybody could read the reviews. And then the final piece of the project is where we're at right now. The last bullet says we're conducting data analysis right now, and we're putting together a report that'll come out of my office by June of this year. Now let's talk a little bit about the 10-point focus that was covered. There were 10 points of legal process that were discussed in each of those individual case reviews, and these are the 10 points. We were looking at things from the time a child was removed to the home, the following issues. Was there a diligence search filed within 30 days? Was there a permanency hearing held within a year? Were there reasonable efforts documented in court orders for achieving permanency? Are there compelling reasons? Language in the court orders of why APLA was chosen as the permanency plan. Was there a signed WTLP, written transitional living program or plan for any of the kids that were age 14 and over? Was there evidence of a connection between that child and ILP services, independent living services for the kids that are age 14 and over? Is there evidence that each child has a connection to an adult? Is there a plan for education, health, and housing? Are there court orders in the DFACS court, in the DFACS file, court orders that appointed child attorneys and CASAs and GALs? And for the kids that are getting close to aging out, were there original documents in the file that should be returned to the children at the age of 18, like their social security card and their birth certificate? So each of those 10 points were discussed in our highlight, in our summaries, and that's what the fellows worked on for each case. Let me give you a little snapshot of what we know, a description of our cold cases. For our 214 cases, around 46 counties in Georgia, spread out around the state, you can see that it's split pretty evenly, males and females. We had a few more males. And split almost down the center, almost in half between black and white. We had 11 Hispanic children. The age range was from 2 to 19, but the bulk of the kids were 13 to 17 years old. The average age was 14. And of those 214 kids that we reviewed, the average number of years that they've been in DFACS care since removal from their home was 6 years. So it was 6 years until they were removed from their home until the time we reviewed the file on average. So for a typical kid in that 6-year time period, they had 9 placements and 5 case managers, so a lot of activity. And as you can imagine, this group of women can tell you stories about reading stacks and stacks of file folders because these cases are very large. One of the interesting things that we've learned is that 85% of our cases, of the cases that we reviewed, the kids had what we would call disabilities or special needs. For example, over half of them have mental health needs. 1 in 3 of those kids have a history of sexual assault. So a lot of things going on in their lives. 3 out of 4 of those kids that we reviewed are still in DFACS care today. As of March, as of last month, we know 3/4 of them are still in care. And of those, half of them are housed in institutions. All right, so what I'm going to do is I'm going to turn this over, and we're going to start talking about things, policy recommendations that we are going to make and discuss in our report. And I'm going to have each of the fellows talk about one policy issue at a time. And I see a question. What we're going to do is go through all the presentations, and at the end, we're going to devote half an hour at least to question and answers. So if you can hold your questions to them, that would be great. So let's talk about the policy recommendations, and I'm going to turn it over to our lead fellow, Ashley Wilcott.
Thank you. I tend to talk fast, so I apologize. I will probably do it today. We're very limited in time for each of us to present, but thank you for allowing us to come, Barton, and share the information. I represent DFACS, so I'm an attorney for DFACS, and I've learned a lot that I didn't know during this project, so it's been a great opportunity. These policy issues are in no particular order. This one was a hot button to me. By the time we finished 1 year, I felt like judicial oversight could really, an increased judicial oversight could really raise raised the bar for what everyone does in permanency for the kids. And I'll start with a few examples. First of all, we reviewed the worst of the worst of the worst of the cases throughout the state, and we had to be reminded of that because they're pretty horrific and sad and tragic to read. A couple of examples. One of the cases reviewed that I actually reviewed the file. There's a child in care, and for 5 years the permanency plan was reunification with the mother who had a substance abuse issue. And the court orders were all in the record, never indicated why that was the permanency plan. Years 2, 3, 4, 5 never said these are the reasonable efforts, these are the services that this mother's had, never said how mom was or wasn't doing on substance abuse. There were motions filed by the department in the record asking for different permanency plans. The court orders denying the motions never said why those motions were denied. So you have a child in care for 5 years, mom's substance abuse problem, and reunification was the goal. So meanwhile, child's in foster care. 5th year, child gets returned to the mom. So, okay, that's great, right? Indicates mom's ready to have the child back. Guess what? Within 6 months, the file shows this child was returned to the department by the mother on the doorstep. I can't do it. Here's my child back. Now, the good outcome was child's up for adoption right now. It's 2 more years after the child came back into care, so 7 years. That's one example. Second example, a 10-year-old. He was in care for 2 years, 21 placements. 2 years, 21 placements. Imagine if you moved 10 times a year. As an adult, that would traumatize you. At least it would me. Third example of one of the cases that were reviewed was a child who, a citizens panel review, and we put in quotes some of the things we saw. Child seems to be heavily medicated. It was a 10-year-old on 7 different mental health drugs. Now, why do I say all this in conjunction with this? I view it as a triangle. Look at the judicial court oversight at the top of the triangle, the tip. You also have DFACS as one of the tips, and you have legal representation. And if all of those are doing and optimizing all of their resources and tools and doing everything they should to the maximum abilities, you're going to increase and improve permanency for these kids. So judicial oversight. ASFA gave the courts the oversight role and state that the responsibility of making decisions in the children's best interest rests squarely on the shoulders of the judge. Now, I know as a SAG I draft the orders for the 2 circuits I'm in. Does that mean they're right? No. Does it mean I make mistakes? Yes. Does it mean that the court should be the one reviewing my orders and saying, that's wrong, we need to change this, this is wrong? Yes. If that were to occur, it would improve my practice and permanency for the kids, right? It would teach us all how to be better lawyers. So the court needs to take on that responsibility. And if they held everyone accountable, you'd see a change in permanency and what could happen. Some of the problems that we observed in reviewing these files statewide was inconsistent interpretation of the laws as applied by the court to the facts that were presented in court. Custody orders expiring multiple times, things that we've probably all heard about and seen in courts where we are. Permanency hearings not being held within the first year removal. No evidence of a guardian appointed, so that you're not always certain that there is a guardian ad litem for the child, although we all know by law there should be. You may not see any evidence of that. It may not be true. Multiple judges on cases. One case reviewed, there were 6 judges on a case. Same case, same child, 6 judges. And also lack of specific findings in court orders. Now, these are required by ASFA and affect funding for the child. But in addition to that, in order to achieve permanency, the court needs to be asking these hard questions. So if it's not being presented, they need the information and put it in court orders so everybody knows exactly what the child has and what the child needs. Can we switch to legal documentation? This directly goes to judicial oversight and the triangle and everybody raising the bar and being more accountable and doing as much as they can. Legal documentation. And when we talked about this, the fellows and we all met on Friday to discuss our PowerPoint and our presentation, and we think you should look at this also as what they didn't have, what files didn't have. So I'm going to say it in the opposite, which is 19% of the files reviewed did not have a shelter care order in them. And these are DFACS records, not clerk's files. So it may be in the clerk's record, but in terms of what's in the DFACS records. In 43% of the cases, there was no 72-hour hearing within 3 days. Last we all checked, that's a law. Didn't happen, at least it wasn't documented in the file. 43% of the cases, an adjudicatory hearing was not held within 30 days. 68% of the cases, an initial case plan was not filed within 30 days. And in 48% of the cases, a dispositional hearing was not held within 60 days. A lot of timelines and legal requirements simply not being met. 11% of diligence searches were filed within 90 days. That's only 11%. So do the reverse and that, I don't do math well, you can see. 89% were not done within the allotted time frame. I'll just quickly say what's up on here and is in the PowerPoint for you. Continuances in 66% of the cases, that's great. A lot of the orders reviewed did not document why they were continued. Maybe a good reason, may not be. 44% of the cases did not have a review within 6 months. Again, this is all required by ASFA. This should be complied with. 48% did not have a permanency hearing within 1 year. And only 3/4 of the applications reviewed had compelling reasons as the law requires. What does all this mean? All this means is that judicial oversight, if improved and the hard questions are asked of all of us as practitioners, then we will improve what we're doing and offer permanency to the kids, and the court can really influence and affect the reasonable efforts made, services provided, and what the real permanency plan is for each of these children. Thank you.
Good afternoon, everyone. My name is Tron Langford. I was one of the Georgia Supreme Court Cold Case Project Fellow, and today I'm going to talk to you about lack of diligent searches. I'm also a practicing parent attorney and a guardian ad litem in juvenile proceedings, and so I know firsthand experience some of the stuff that we all encounter as attorneys in juvenile proceedings. But statewide, diligent searches filed with the court were only documented 1/2 of the time in the cases that we have reviewed. And in those cases, the diligent searches filed were inconsistent across the board, because good diligent searches leads to permanency and adult connection. They should be done very early and they should be done very often. Okay? We must search all possible relatives. That includes the maternal and paternal. Oftentimes, in the cases that we have reviewed, we found that only maybe the maternal side was, searched and not the paternal side. Ask the child for information. Write letters to the family members. An example of where the county DFACS actually did a great job in contacting the family members with Coquitlam County. They had written letters to the family members, okay? Being diligent sometimes means that you have to use unconventional methods, okay? Such as social networking website, like MySpace, and there's some other social networking website that we could all use. In one case, a very resourceful Chatham County case manager used MySpace to find a child who was about to be placed with her relative, but the child would not respond to formal methods of communication. Okay, 57% of the children in custody lack accurate searches. Some of the accurate searches use misspellings of relatives' names, so there were no matches found. 48.6% of cases were coded for defects, systemic factors delaying permanency. Lack of diligent searches can indirectly affect children's behavior. Most children want to be placed with their family because they want to be with their family, and they will often misbehave thinking that they will be able to be placed with their family member then. For example, there was one case in Fulton County where the child had indicated if she was placed with her grandmother, she would totally stop misbehaving. Having a great but unused diligent search report is like having a very intelligent employee who never uses his or her skills to accomplish anything. For example, while there were 6 diligent searches and 2 accurate searches conducted in one Floyd County case, permanency was not achieved for that child because the child has never met any of the relatives and the relatives has never contacted the case manager. Because diligent searches, while were conducted, they were not used. That resulted in the child not knowing his own family. And sadly, placing him with his own family now would more likely be disruptive to his life. So we all need to do our part in this, and I hope that we all learn something from the Cold Case Project and bring permanency to the children in foster care. Thank you for your time.
Afternoon. My name is Brooke Silverthorne. I am a attorney for defects in Gwinnett County. And I am going to talk about court orders and the boilerplate language that's required. Just an aside, the bulk of what I'm going to talk about is the APLA cases. But first, we all know that reasonable efforts are required to be in court orders at various stages in the case. At the 72-hour order, it's required reasonable efforts to prevent removal are required. In the cases that we reviewed, in 69.6% of the 72-hour orders addressed reasonable efforts to prevent removal. However, there's an interesting contrast because in only 43.5% of those cases were there specific details about what those efforts were. So that's a really important distinction, I think. It's good to put in reasonable efforts, but it's important to go that extra step to talk about what those reasonable efforts were. When we got to the adjudicatory hearing, the number jumped up to 83.6% of the time, 81.1% of the time, reasonable efforts were listed. And then when we got to the permanency hearing, if the child had been in care for at least a year, the reasonable efforts language jumped up to 83.6% of the time. So as the case went on, the reasonable efforts language in the orders did improve. Now, as we stated earlier, 214 cases were reviewed. 78 of those were APLA cases, cases where the permanency plan was another planned permanent living arrangement. That's 36% of the cases that we reviewed. In 53% of those cases, there's a compelling reason why APLA was chosen. But in 17% of the 53%, I know that's kind of confusing, the fellow who reviewed that particular case didn't think that the compelling reason that was listed would pass the federal review. And in 11% of the cases, compelling reasons were found somewhere in the defects file, just not in the court order.
Can you state what APLA is?
Yes, another planned permanent living arrangement. It is, under ASFA, there are 4 preferred permanency plans prior to choosing an APLA: reunification, adoption, guardianship, placement with fit and willing relative. If none of those are the permanency plan, then the 5th category is APLA. The compelling reason requirement is that if you're going to choose APLA, you have to document in a court order the compelling reason why one of the 4 preferred permanency options is not in the child's best interest. So, the statistic about the 11% being in the file but not in the court order is important because we can see that defects made efforts to document a compelling reason. There may be a compelling reason. If it's not in the court order, it's not going to count for us. It's not going to pass a federal review. So it's important that everything that defects does, the work that they put behind it, gets into that court order so that we can pass. Now, another startling statistic to me was that the #1 reason listed in our cold cases, in 35% of the cases, the compelling reason listed was the behavior of the child. That is not a legally compelling reason. The #2 reason was that there were no fit and willing relatives. Again, not in and of itself a compelling reason. And another high percentage was age. 19.3% of the cases listed age. In one case, and I pulled this language from the review, the compelling reason listed in the court order specifically said, the child is 17 years old and the possibility of adoption is slim. Well, that child had been in care 6 years prior. So at this point, when she's 17, perhaps it's slim. What about 6 years ago when she was 11? So I'm running out of time here, but I want to say that another planned permanent living arrangement, plan to me is the key word there. think about synonyms of planned. It's deliberate, it's intended. So when we're gonna pick APLA, we need to make sure that it is deliberate, that it's intended, that there is a specific reason. So one of the recommendations that came out of this project is that DFACs develop an internal protocol for any time they're going to choose APLA as a permanency plan. There's a committee of people that get together and they talk about what is the plan going to be. It would also be important to have the child be involved in that plan. I mean, after all, it's the child's life we're talking about. So that would be the other recommendation, is that the child be part of that group. Thank you.
Good afternoon. My name's Pat Dono, and I am a private practitioner up in Cobb County. I have experience as a SAG, a parent's attorney, and am currently serving as a guardian ad litem in Cobb County. And I'm going to address the lack of a connection between the child and an adult, not just an adult, but a stable, functional adult. That's something we need to remember sometimes. One of the issues that we have come across is that children are being placed in institutions that are so far from home that the families can't get to visit the children. The children who are removed from their homes are very often, the families are very often dealing with poverty issues. Very often those families don't have a working vehicle, and yet the children are being placed hours from home. The parents have a very hard time getting to see the children, and then when it comes time for termination, DFAC says the parents didn't maintain a meaningful contact with the child or a meaningful relationship with the child. So it's too hard on the family, and it's very, very hard on the child not to be able to have regular, frequent contact with their family. Another issue that we identified is a problem with the fathers. Several of the cases that I reviewed personally, we couldn't tell who the real father of the child was. Sometimes mom's live-in boyfriend was identified as the father of the child, and nobody ever disputed that, and they didn't look any further. If there is a stepfather, very often he's considered the legal father of the child for purposes of these cases, and we never find out whether there's a legal father or a putative father out there who may have relatives, and right away we're wasting a whole pool of relatives that might be helpful to this child. So we need to make sure we identify everybody who has a relationship to this child and see if they have any relatives that might be interested in being, even if not a placement, at least a contact for the child. Some courts are not seeking out the putative fathers right now because there are no funds available to appoint them attorneys. This is unfortunate because it essentially robs the child of that pool of contacts and relatives. The cost of providing a lifetime of care for a child is much, much higher than the cost of appointing an attorney for a few months or even a couple of years to represent that father. In a lot of the cases we saw, and especially when these children are in institutional settings, the only people with whom, adults with whom they have regular contact are their case managers, their therapists, and the people who work at the placement. It is devastating for a child to be so lonely. When they grow up, where are they going to go? Who are they going to call on if they have a problem? They're 19 years old. They're trying to make it on their own. They need somebody. They don't have anybody to call. Where are they going to go for Thanksgiving? These things are daunting for somebody who is just coming out on their own out of foster care. If that's the future that the children who are coming through our foster care system have to look forward to, are we truly serving those children? 16% of the children in this study had no connection whatsoever to an adult. So, We need to go back to asking if the child has relatives. We talked about diligent searches. We had a case in which a child insisted that she had an aunt and she wanted to be with that aunt. And the case manager looked at the record and actually told her, "You don't have an aunt so-and-so." Later on, fortunately, the aunt tracked the child down, and DFACS found out she truly did have that aunt, and she was placed with that aunt. We have looked at cases in which there is a relative who could be a connection for the child, but the department won't allow them to have access to the child because they can't have the child come and live with them. For whatever reason, they're not a potential placement. The department actually denied them access because they couldn't be a placement. We don't want you to have a relationship unless you can take the child. We've seen situations in which relatives are actually denied contact with the child because the child doesn't know them. But they're potential placements, and the child needs to get to know their relatives. So we need to make sure that the relatives have access to the children, unless for some reason it's going to be detrimental to the child. But there needs to be a finding in a court order. And the people involved in the case, the guardians, whoever's representing that child, needs to make a motion to the court to allow that visitation. We need to focus on children who have no connection. Look and see if there's a CASA involved in the case who has befriended the child and is willing to stay in touch with that child. Look and see if there's a mentor. Is there somebody in the community? Can the child become involved in community activities in which they might find someone? I had one case where a case manager was trying to find a potential adoptive placement for a child, and he met several families, and he was a teenage boy, and she was being very diligent, and he wasn't comfortable with any of the families, and he finally said, I don't want to go with any of these families. And she said, well, then tell me what you do want to do. And he told her about a family, a friend, whose parents were very nice, and it turned out that this family was interested in having him placed there. And they have permanent guardianship of him now. So it's important to keep an open mind, talk to all of the people involved, and especially talk to the child. Find out who they know and where they think they would like to be. The number of kids in this state who have no connection to an adult should be 0. Thank you.
Good afternoon. Good afternoon. My name is Carlise Greer. I formerly represented the Fulton County Department of Family and Children's Services. I've also done a little bit of child advocate work in both Fulton and DeKalb, and a tiny bit of parent representation. Currently, my practice focuses on work in Superior Court and guardian ad litem work. I am going to talk about policy issue number 5 to start off with, relative custody and visitation. And Pat, when she just spoke, hit on one of the things that I wanted to mention. We were actually looking at a case file, and the department did not place the child with the relative because the relative, in this case a brother, was a stranger, but instead placed the child with a stranger foster family, another group of strangers. And I don't know where the judicial oversight was. I don't know where the guardian, CASA, child advocate was, or even, the parent attorneys, if they were involved. How does this kind of case come to court and nobody says, but wait, that makes no sense? And so when we're looking at these relative custody and visitation issues, we also need to bring that sort of common sense lens to it. Legal orphans, as Pat just mentioned, often have no connection to an adult, so I'm not going to belabor that. Something else that we found, though, that prohibited relative and, in particular, parent visitation with a child were drug screens. In many of our cases, the parents have substance abuse issues. And we were finding in reviewing the files that the department, without taking the cases to court, would unilaterally say, well, if the parent fails a drug screen, you don't get to visit with your child. And that is just legally inappropriate because, as we all know, the parent has a residual right of visitation with that child unless it is court ordered. Even if a court is asked to look at that issue of relative visitation, we found in discussing our cases that we need to be very careful about a court unilaterally terminating a parent's right to visit with the child because it punishes the child. And in many of the cases, as we've noted, we saw children with no connections to adults. And so you cut off parent visitation, the child isn't visiting with anybody else other than their therapists and their caseworkers, and they're left with no contact with anyone beyond someone who is paid to work with them. I know when I represented Fulton County, we had a case where DFACS, and I represented DFACS, I as the attorney, and I thought it was the right thing to do, we asked to terminate parent visitation. And the parent had not only failed a drug screen, but they had brought someone else's urine in to use for the drug sample, and we probably all heard of that. And so we thought, this parent seriously has a problem. How can you begin building or continue a relationship with your child if you are, bringing in someone else's urine for the drug screen? When we went out of court and told the child about this, the child was inconsolable. I have rarely heard such anguish from a child, and it gave me pause. And so one of the things that we really do need to think about when we are reflecting on these cases, especially since 16% of the children come out of care with no adult connection, is thinking long and hard before we use these sorts of measures when a parent does not follow the requirements of a case plan, even if it is brought to court. And note that DFACS cannot do this unilaterally. In addition, we sometimes saw visits and phone calls withheld as punishment when a child misbehaved. And we know that some of these children do have serious emotional and behavioral issues, and you do have to correct that behavior. But withholding telephone calls from the mother or the father because the child misbehaves, we are not aware of anything legally that makes this an appropriate form of punishment, yet we saw this documented time and time again in the files, and so it's something that the advocacy community needs to look at. In addition, we saw that relatives, as someone mentioned earlier, who were not able to be placement resources were not further explored as contacts with the child. There was one case that we just all thought was very egregious. It was a grandmother, a maternal grandmother, that was an over-the-road truck driver. She was sending cards and letters to her granddaughter saying, I want to visit her, I want to see her whenever I can, but this is how I make my living, by driving a truck. So, she can't come live with me in the truck. And DFACS said, well, if you can't have her placed with you, you can't visit with her. And not only are we not going to allow you to visit with her, we aren't going to give her your cards and letters. And so again, this child was left just thinking, nobody cares for me, when there was a grandmother saying, I want to see this child, I want to communicate with this child, I want to have a relationship with this child, but I have to work. And this is my job, and it prevents her from living with me. So we really do need to rethink those relative issues and how we involve relatives in the process. Just because a family, for whatever reason, may not be able to have that child placed with them, it makes no sense to cut off the family network altogether, especially if you have stable, committed relatives. So that was one of the hardest issues that we saw. Policy issue number 6, children not in court and without representation. I think one of the most startling things for us, and I don't know that I realized it until we did the cold case project, is once parental rights are terminated in most counties, representation for the child ends. And so you have children, and in some counties it actually stops at the deprivation phase. Once the child is adjudicated deprived, the attorneys are pulled and they may be reappointed if there is a TPR. But after the TPR, in almost every county that we reviewed, representation stopped. And so you have a child that is a legal orphan. Typically that child does not have an attorney, that child does not have a CASA. The CASAs are pulled at the TPR. The child doesn't have a guardian ad litem. So at that point, the child is a legal orphan of the state. There is limited oversight, and that child has absolutely no advocate. So if the child is not getting notices of changes in placement, there is no advocate for that child. If that child is being moved from school to school or home to home, there's no one to advocate for that child. If that child is potentially being over-medicated in a psychiatric residential treatment facility, there is absolutely no advocate for that child. And we thought that was totally unacceptable. So one of the key facts that we want to try and get out is even if parental rights are terminated, the child still needs to have an advocate for him or her in court. Children were often excluded from the court proceedings, and we know it's a delicate balance. Children need to be in school, yes, but children also need to be involved in these court proceedings that affect their lives. They need to understand what's going on. They need to hear what is being said about mom and dad, what the caseworker is saying, what mom and dad is saying. Because when we hear from the children, we did not interview the children as part of this process, but when we've talked to children independently through the Empowerment Project or other issues, they indicate when I'm not in court, I can be manipulated because mom will say one thing, DFACS will say another thing about what happened in court, and I don't know what to believe. If I'm there, I can make my own assessment. And I know when I first heard that, I was a little uneasy about this. These children have been abused and neglected and some horrible things. And I remember I asked one of the empowerment children, who is an adult now, about that, and he's like, well, I experienced it. Talking about it in court, for me at least, is no worse than having gone through it. I was there, I know what happened. And so obviously that's something you have to evaluate on a case-by-case basis, but as a child attorney, we need to be asking our clients, do you want to be in court participating in this proceeding? And if so, make sure that they are there. We need to make sure our children know the law. They need to know that if your placement is being changed, you have a right to 5 days notice and the right to object, not just your parent. You as the child have the right to know when your placement is going to be changed and object. You have the right to stay in your same school until the end of the school year and have someone transport you. You have the right to have a detailed, child-specific written transitional living plan tailored for your needs, and the department has to pay for what's in it. Our children don't know their rights sometimes, even when they are appointed guardian ad litem or child attorneys, and we need to make sure that they do know those rights and are advised of them. And that is something else that we didn't see in the file. I don't think any of us saw many orders actually appointing the guardians ad litems or the child attorneys. And so it was not always clear at what point someone was coming into that process, and that's something else that needed to change. And one final point, we needed to, make sure that when the children are involved, it's in a meaningful way in all phases. If there's a citizen panel review in lieu of a court proceeding, the child needs to be part of that citizen panel review. We talked about the children going to court and really being involved in a meaningful way in their case plan, not just send a written transitional living plan to look at after it's done and maybe or maybe not sign on it, but truly involving the children in the process in a meaningful way that gives them a voice. And so I thank you for your time.
And before I get to my topic, I think one thing to add to Carlisa's, which is really important when we're talking about children and representation, is youth empowerment, which are foster children who have aged out and are now advocating for current foster children, has a saying called, nothing about me without me. So I think it's a really important thing to take home with you and listen to when you're representing these children and making sure that they're involved in the process. I've got the sexy topic. Literally, the sexy topic. My topic is about teen pregnancy and how it's affecting permanency. Before I get started, I do want to talk about a couple of kids that we went and reviewed their files on. And I'm Doris Good. I'm a parent's attorney, for those of you who don't know me. My first child is Michelle. Michelle was removed from her mother. She was never placed into a permanent family or family situation. and by 15, she was pregnant with her own child. And she is now 18. That child is now 3. She is a legal orphan aging out of foster care, and her child is currently up for adoption with no current prospects. Faith was removed at age 2 from her mother, grew up in foster care, so had her child at age 15. And currently with her child, she's at the point now where they're about to take that child away from her because she can't care for that child. Baby Shelly was born to a 14-year-old mother. Mother can no longer care for her because she's 17 in foster care, about to age out as a legal orphan because they never found her a permanent family, and is in fact pregnant with her second child at that age. So when we talk about the department and custody, I think there's so many people that forget that you are in loco parentis, meaning that the department is standing in the place of the parent, and it refers to the legal responsibility of the department to take on the functions and responsibilities of a parent. And unfortunately, one of those dreaded talks as a parent is sexual education. It's something that is not being taught in many of our schools, and as a result, the foster care youth aren't being exposed to it, and they don't have parents to talk to them about it. Foster children are more likely than their teen peers who are not in foster care to become pregnant. The National Casey Alumni Study found that the birth rate for girls in foster care is 17.2%, which is double the national rate for girls not in care. We found in our cold cases that 10% of the children were known to be consensually sexually active. Less than 2% were using birth control or had been even exposed to birth control options. And some of our findings in this area aren't as prominent because this isn't actually a issue that we came up later for us. We didn't originally look at it, and then we just started seeing it so many times in our reviews. About 15 of the 240 kids are teen parents, pregnant or parenting teens. As far as what wasn't done for these girls and boys, because some are boys, a lot of these children are sexually abused and exploited children who are acting out sexually as they get older. A lot of them are children with mental health needs or vulnerabilities. Most foster youth don't have access to contraceptives, and when pregnant, there's no addressing of those options. I think we're put in a very difficult position because a lot of people have an extremely strong moral or religious belief about what we should and should not be telling our children about sexual education and the possibilities if you are pregnant. But what we're finding is that these children are continuing to have children and just continuing the cycle. The department can't raise the children they've got. They don't raise the children they got, and then they don't educate those children on raising children, so then they have children, they're now raising those children. So it's just a really horrible, vicious cycle. And I think that in order to address the problem, I think, one, we need to aggressively treat sexually abused and exploited children. If you have them, if you represent them, if you're the department or the parent's attorney, they need to be in therapy immediately, as often as possible. You're going to spend a lot less money treating them aggressively at the front than you are caring for them and their 2 children who are now in foster care. And the next thing is we have to have comprehensive sexual education. These children need to be told the consequences of pregnancy. And I don't know about you all, but I had to carry an egg around for like a week in high school. And that's something that, you know, it teaches you the responsibility, and these children aren't getting it. They aren't understanding that it is a huge responsibility, and unfortunately, they have no connections to adults, so they're creating their own. My plan, if I could take over the world of comprehensive sexual education for teenagers, really would be to add that to ILP plans or even sooner, for it to be a yearly requirement. If a person or a case manager is uncomfortable with giving that talk, then having someone else in their department or their office who is. If that person isn't, talking with the parents' attorneys and the children's attorneys about having those talks. We had, in closing, a last child who gave birth at a hospital at the age of 14 all alone because she was a foster child. She had no connections to a family, and her case manager didn't even show up at the hospital. So it's real important that we address this issue, because this is, 30% are going to come back into care, or already be in care, and then be born in care, and then age out without having a family. So, thank you.
Excuse me, we have 4 more policy issues we want to cover, but let's take a short break. We'll break for like 10 minutes and come back, and we'll pick up with Dorothy Murphy.